By way of introduction, let me just share with you a statement that Chief Justice John Marshall, the longest-serving Chief Justice of the United States, 34 years he was in that role, said nearly 200 years ago that our Constitution was, quote, intended to endure for the ages to come, and consequently to be adapted to the various crises of human affairs. Well, our Constitution has endured a lot of things, the Civil War to the Cold War, the Industrial Age to the Computer Age, from states' rights to civil rights. And how well has the Constitution mediated society's most basic conflicts? What are the most important issues that remain unsettled in constitutional law? And can our Constitution be readily adapted, as Chief Justice Marshall suggested, to the challenges that await on the horizon? Challenges like terrorism, globalization, diversity, and technological change. These are some of the questions that will occupy us today as we discuss the path of constitutional law, continuity, crossroads, or crisis. Jesse Chopra, let me begin with you. And I'm going to begin at sort of the 30,000-foot level. So I want to pick up on Chief Justice Marshall's quote that the Constitution was intended to endure for the ages to come. So very broadly, in what ways do you think the Constitution has served us well? And are there things you think that need to be changed at some fundamental level?
I think the Constitution has served us very well. It is for after all, over 200 years, 225 years, 20 years. And it is, we often say that, it was the product of genius. And that is a phrase that's often thrown around in lots of respects, but I really do think it's true. Very few amendments. There obviously have been a substantial number, particularly in the last 60 years, of very controversial decisions. They came earlier as well. Some I think are right, some I think are wrong. Most all of them have had to do, at least those of high controversy, with the court's either enforcement or refusal to enforce certain individual rights. And whether it involves the school prayer or abortion, just to name two. But I don't think we ought to change that. It seems to me that these are, not to say that they're not important issues, they're very important issues and sometimes to large percentages of the population. But I do think that there are several changes that we ought seriously to consider making that go to the core of our representative democracy. There, I think, if we're going to adapt it to future needs, that's where adaptation is needed. And I recall being asked that very question, I think it was in 1987 or 80, we were celebrating 200 years of something at the time, maybe the convention or what, and I thought about what my response was, and I still agree with it. First of all, I think we ought and I think virtually all of these would take a constitutional amendment, particularly the first one, and that is term limits for all federal officers. I'll leave it just that vague. I think we ought to reconsider. We do have term limits for the presidency. Whether 2 terms is right, I don't know or not. I don't know what ought to be right in terms of details. I have ideas as to some. But we have more contested elections, fewer contested elections, for example, in the House of Representatives than they used to have in a Supreme Soviet. I mean, truly contested elections. Second, I think we ought to look at this question of campaign finance. I think it's an enormously difficult question, the clash between the power of money and the development of our democracy. And how you resolve that, I don't know. But the Supreme Court hasn't done a very good job. And that's not so much as to criticize them as to say I think it ought to be rethought on a broader basis. And the third is really is part and parcel. These are all three go. And this, as I said when I responded the first time, if I have any credibility left, I will destroy it now. But I would seriously reconsider the scope of the freedom of the media, the freedom, the protection that the First Amendment gives to what we used to call the press, but now to the media, because I think that it cannot be that in 1787 or 1789, the power of the media to influence our political system could have been perceived. It's one thing to be critical, and it's another thing to call the tune. And I think we've come everything is directed to that today. The raising of money is directed to that, and that's the lifeblood of American politics, and I just don't think, and that is just directed to use of the media. Almost always television, now direct mail too, and I guess some use of the internet. Anyway, I'll stop there.
Okay. Thanks, Jesse. Let me turn to Judge Fletcher. So Jesse laid out a set of considerations that speak to the Constitution as a document that orders democracy, that structures it, channels it, that facilitates it in some way. But the Constitution has other faces too. Has faces that deal with substantive rights, specific liberties that are guaranteed, limitations on what government can do. Now, in other settings, Judge Fletcher, I've heard you say that our Constitution is a somewhat old-fashioned Constitution. It was written over 200 years ago. And there are more modern constitutions on the books in places like Europe, in South Africa, where in the last half century there have been a longer enumeration and a fuller elaboration of specific rights and guarantees given as a constitutional matter. I'm just wondering what you think are some distinctive features of our Constitution for having been written so long ago, and what you think of as some of its strengths and limitations.
We do have quite an old-fashioned Constitution. At the time, it was a marvel. At the time, it was a creation undreamed of elsewhere, except perhaps in the minds of the French philosophes. It was a magnificent achievement. What did it do? But then in a moment I'll say what it didn't do. It's primarily, as its name suggests, although we don't usually use the word in quite this way, a constitutive document. That is to say, it constitutes a government. It sets it up with, at the national level, three levels, the famous separation of powers, the legislative branch, the executive branch, and the judicial branch. It also sets up or builds on the states so as to establish, when you combine the federal Constitution with the state governments, a federal system of government. So we divide powers not only among the three branches of the national government, but we divide powers in the federalist sense between the national government and the states. As part of that federal system, the Constitution gives to the national government certain enumerated powers, and by implication denies powers not affirmatively granted. And then, particularly in the Bill of Rights, an afterthought assumed by the drafters to be self-evident, but in the nominating convention, so many people worried that they were not all that self-evident that we enumerate many of the Bill of Rights, leaving to one side the specific statement, well, there's some that are not enumerated but are here nonetheless, as we see in the Ninth Amendment, certain very specific prohibitions on the exercise of governmental powers. So, for example, in the Fourth Amendment, there's a specific prohibition against unreasonable search and seizure. In the Fifth Amendment, specific prohibition against coerced confession. In the Eighth Amendment, specific prohibition against cruel and unusual punishment. There it is. Now, after the Civil War, after the document was redrafted, in the phrase of one of my teachers, Charles Black, by the logicians of Gettysburg, we add the Equal Protection Clause. But even there, it's a very limited right that's given. It's not a non-contingent obligation upon the government to provide rights. It is rather an obligation on the government to provide equal protection, which presumes that the government might grant something to some party or some group of people, and that, as it were, granting of rights by grace then triggers a further obligation to grant them equally to whoever might be similarly situated. We have nothing comparable to what most of the post-World War II European constitutions have, which is to say affirmative obligations upon the government written into the Constitution to provide health care, to provide education, to provide food, to provide shelter. This document, our document, is entirely silent on such points. Some of the state constitutions have this, but the federal government, the federal Constitution, does not. During the heyday of the Warren Court, there were some attempts to try to do some of that in a kind of the normal roundabout way of constitutional adjudication. So, for example, there was argued for a time, and it narrowly failed at the court, there was argued for a time that there was a fundamental right to education, which could not be abridged except in certain circumstances. The court rejects the argument, as indeed, if we're talking about text, I think it had every reason to do. But as we think about that Constitution, it's well to remember that there are not, how do I want to say this, there are a number of important things about our lives and our lives in relation to the government that are simply not in the document. The document is largely a document that constitutes a government and then limits the document. It is a document that provides that the government can do only a certain number of things to us. It resonates with the essential individuality and liberty-loving characteristics of our population. That's the good part. The bad part might be because it is largely a document of negatives, largely a document of what the government cannot do, and largely a document, at least in the last 50 or so years, enforced and given meaning by the United States Supreme Court. It is a document that now, in the hands of the United States Supreme Court, forbids various arrangements by which we might better our lives.
John, do you think that, so Judge Fletcher has sketched out a sort of a view of the Constitution that views the absence of positive rights, affirmative rights to government provision in a variety of areas as a limitation in terms of what our constitutional fabric gives us. Do you agree with that characterization? Is that to be regarded as sort of a limited set of ambitions for the core values of our nation, or is that an important piece of the design that such limitations exist in our Constitution?
I guess one way to respond to your question is if you look at the Constitution, it is very different than the European constitutions. I think Judge Fletcher is quite right that it doesn't express what we think of as positive welfare rights that are typical amongst European constitutions today. Another feature of it that also goes to this point is how inefficient our government was originally designed to be. You look at the separation of powers, a president, Congress, and judiciary, they're separated. We don't have a parliamentary system of government with which it would be easier to enact broader social changes than our Constitution permits. We have federalism, which also makes it difficult for the federal government to enact sweeping legislation. It's almost as if our Constitution was designed to make it very difficult for the government to do anything. And I think that really does express a bias that people had at 1787. It probably was the 200th anniversary of the Constitution you were celebrating, Jesse, but you know, when you've seen so many anniversaries of the Constitution, you don't place any great store in 200 versus 190 or 210. And I think that's one striking thing I think people from other countries have when they see our Constitution. It's hard to see how it would work. And that makes it, I think that makes the United States less prone to swings in policy than other countries might be. And so and this comes up in this question that we're debating these days about the use of foreign law and international precedents in our courts, which is, one way to think about it is people, in a way, arguing that we ought to catch up to what's been going on in the legal systems and the constitutional systems in other parts of the world. But one thing our Constitution does, it seems to me, is it makes it very difficult for our government to move in any one direction very swiftly or to change directions very quickly. From a day-to-day moment, seems quite inefficient and ineffective. But it's an open question, I think, whether in the long run that is actually better for the country or not, to have a very difficult political system that makes change very hard to occur. In that sense, it's a document that seems to reinforce tradition, and in that sense it is conservative with a small c, conservative, that it's more like it almost sort of seems to put into place Burkean objectives of making change incremental and slow. But that also means that we don't go in for the fads of the day in public policy either. And as academics or intellectuals or people in universities, it's very easy, I think we have the right answers to the right solutions or answers to public problems because we've studied it very hard. But you know, one thing American history might point out is that often we may not, and that it might be better to engage in slower change and broad-based reform all of a sudden.
Okay. Let me bring Aaron Murphy and Chris Headley into the discussion. You know, from your respective vantage points in the areas in which you work, do you agree that constitutional law is in a state of flux? If so, how is the state of things today, as we look at the challenges on the horizon, different than a situation that might have obtained at some earlier point in our constitutional history? Or is our path along constitutional law a fairly stable one, and we're just sort of nibbling around the edges of some basic principles that have lasted us and will last us still for some time to come? Aaron?
Well, in constitutional criminal procedure, I think that we are confronted with a new set of problems. I do think that the Constitution has the flexibility to deal with them, but I mean, I think some of the underlying assumptions that have been present in the last 200 years are starting to ebb away a little bit with technological changes. So, for instance, for 200 years, the physical world more or less defined the way we thought about constitutional protections in criminal procedure. We had, obviously, the Fourth Amendment, the Fifth Amendment, there to protect you against search and seizure and interrogation in a world where those things were often explicitly referenced to, say, property rights or ideas of trespass or physical bodily integrity. So you were protected by things like walls or your physical skin in terms of invasions that even could be imagined. But in the new world, the modern world, we have technologies that can see through walls, see through bodies, see through brains even. And so that presents a new set of challenges that I think the Constitution has to grapple with. We're also linked to one another, as we all know, in a different way in which we were previously. We're now very much in this information society where not only do we inevitably expose ourselves at some level to one another merely by existing, taking out a credit card, you know, riding on public transportation, taking an airplane, but also those things leave traces. So in a way in which, you know, the sort of old world perhaps you could have moved through with cash if you wanted to retain a certain amount of anonymity, that simply doesn't exist anymore. It's virtually impossible, and as a recent transplant to California, I can tell you from personal experience, it's virtually impossible to exist in this world without an identification, a driver's license, a credit card, things that link you, bank accounts, and so forth, to those around you, much less email, telephones. Are these brand new problems? Not really, I think. We've seen the court, since the advent of phones or planes or trains, dealing with these issues and how to define ideas, moving from strict ideas of physical limitations like property to more nebulous concepts of privacy. But in general, the Constitution has focused on the physical world as a way of limiting police intrusions into our lives, and it's also focused in sort of on the individual and not on third parties and the information that third parties can share in terms of limiting those protections. And so I think as we move forward, we have to think about the constitutional protections against government or state intrusion into our private sphere in a broader sense, in a sense that takes into account the way in which inherently we're linked to one another, and the physical spaces that we used to be able to retreat into don't exist as clearly anymore.
Okay, terrific. Chris, I'll quote something for you to react to. Your former colleague, Larry Tribe, at Harvard, recently said that, this is him describing constitutional law, we find ourselves at a fork in the road, at a point where it's fair to say things could go in any of several directions. Do you agree with that? In what areas could constitutional law really go in any of several directions?
I think that, well, Larry's certainly right. I mean, in some trivial sense, he's right in the sense that the number of 5-4 and 6-3 decisions in a range of subject matter areas is what has focused so much public attention on these Supreme Court nominations in issues of federalism, the relationship between the federal government and the states, the regulatory powers of Congress, the federal government, the abortion rights and privacy issues, certain other civil liberties issues, certainly in the civil rights, racial justice arena. So there are many contexts in which the court could move dramatically in any of a couple of different directions. I guess I would defer to others on the panel as to whether this moment is unique in that respect. My sense is that at most moments there, through our history, there have at least been the intellectual possibility of moving in different directions. As to whether or not the ideological composition of the court made the questions closely contested, that's a different matter. But one of the extraordinary things, for good and bad, about the document is its open-textured character, admitting of varying interpretations, admitting of new kinds of life over time, much to the chagrin of originalists. So in that sense, there are choices always to be made in the way in which we live our living Constitution. Something I think that many people don't focus on is the extent to which so many of the important things aren't addressed by the Constitution, the answers aren't provided by the Constitution. I'm building on something that Judge Fletcher said. For many, many things that we care about, that we would want to accomplish, interests that we would want to vindicate, that we would want to advance, or that we would want to oppress, the Constitution's basically silent, and in some sense it's really left to politics to decide. What we do about global warming, what we do about class inequality in America, what we do about access to health care. The design seems to require that we go through political struggle to answer these questions year by year, generation by generation. So there is, of course, the question of whether our Constitution in that sense is too thin, reflecting too little of our changing collective aspirations, our ideals. But putting that to one side, there's the question of whether the Constitution not really stands aside, but in some respects gets in the way of doing some things that we might want to do collectively. And let me just, if I can just say a word about that for a second. I've worried in my scholarship, but also in my political and policy work over the years, about the puzzling difficulty of how many tough questions there are in social and economic policy that the government just seems to do a terrible job at answering, especially at answering in a timely way. Right? So you can ask whether or not our political arrangements, and Jesse Chopra was getting to this a little bit, you can ask about whether our political arrangements are in fact ideally arranged so that we make good public policy in a timely way, that voices are heard, are represented effectively, and so forth. And I have some severe doubts about that. I have severe doubts about whether this 18th century document, which I'll remind you was adopted because the Articles of Confederation proved ineffective at addressing some of the challenges faced by the 13 original states. Whether the conservatism that John Yoo and Willie Fletcher described is going to get us in trouble in the 21st century. Whether the kinds of challenges that we are facing actually require a national government that is fleeter of foot, that is more responsive to and more capable of effectuating collective aspirations at the national level, as against what state governments might do. I mean, the 18th century notion of state sovereignty, which is enjoying a renewed favor among some of our Supreme Court justices, in my judgment, is antithetical to a 21st century nation facing challenges of globalization and diversity and economic and technological interconnectedness. I think it's dangerous to put too much emphasis on localism and state sovereignty, given the challenges that the nation faces. And the other dimension of my anxiety about whether the Constitution will serve as well in the next century as it has in the past two has to do with the continuing problem of seeing to it that in our national aspirations there has to be an effective counter-majoritarian protection for those who historically have been left out and who even today, as numbers increase, still disproportionately lack political and economic power. Notwithstanding the Equal Protection Clause, notwithstanding the Due Process Clause, just looking at the aftermath of Katrina, you can see that the divisions in our society were not being effectively addressed by local, state, and national governments. That the agenda for making investments to protect people was not being set by the people who were most vulnerable. Even if you won't say that our Constitution should affirmatively, in the manner of other constitutions in other countries, should affirmatively protect social and economic rights of some sort, I think there is still the possibility that the mechanisms of governance prescribed by the Constitution are too cumbersome, too inefficient to allow politics to work as we need it to in the century ahead.
I don't disagree with a lot of what Chris's motives are, in the sense that it would be nice if we could immediately implement a lot of the social changes or the right answers to certain problems. I think the Constitution just simply has built into it almost purposeful defects to prevent that from happening. I guess one thing I would say is that the reasons for that is, one, the framers didn't think that the federal government would be the answer, that the answer would come from states or something we've not mentioned, private civil society, charities, religious groups, private interest groups, and so on, local organizations. The second thing is I think the framers were very suspicious of human passions. That it wasn't that they didn't want people to vote their preferences and have them recognized, but that they were worried that people would just be subject to the passion of the day. And in some sense, they were, I think, skeptical about human reason on a day-to-day basis, that you could actually come up with the right answer. They're worried about, that we place the short term over the long term. So the way I explain this to popular audiences is that this reaffirms the deep meaning of the movie Forrest Gump. Because you could see our Constitution as Forrest Gump, right? Sort of cluelessly moving along, not going along with the latest trend of the day, which is represented by Jenny, right? Who I commonly think of as being the Europeans. But so Jenny is always struck by doing the latest fad, right? And in fact, where does she go in the 60s? She goes to Berkeley, of course. And she always comes back to Forrest Gump, who sort of is inefficient, right? He doesn't always have the best idea, and he's sort of moves slowly in. But at the moral of the story is at the end, he's sort of in a good place and takes care of her, which is kind of what we've done with the Europeans these last 50 years. So, anyway, I think I'm going to leave it at there.
Are there any reporters in the audience? Anybody else want to take a swing at this? Go ahead, Judge Fletcher, and then Jesse. Go ahead.
I'd like to make 2 points. One, I think, fairly quick, and the other may take a moment. The first one is there's a current debate going on. It's a version of debate that we've had for a while, and that is, to what degree should the United States Supreme Court refer to foreign law? There's a narrow version of it, which is to say, to what extent should it refer to foreign law as it interprets the Constitution? There's a broader debate in terms of to what extent should it talk about foreign law at all? The constitutional debate showed up in two cases, or two kinds of cases. First, the death penalty. The opinion written in Atkins versus Virginia, in which the Supreme Court struck down the death penalty for the mentally retarded. Justice Stevens referred to practices around the world. Now, it was tucked into a footnote after an enormous discussion of what happens in the various states. There's some textual, of course, basis for it. It's unusual, and what's your frame of reference? Is it unusual merely with respect to the United States, or is it unusual with respect to the world community? And some conservatives are very unhappy that foreign law can even be mentioned in a footnote. The other case, or it's two cases really, are consensual sodomy and the criminalization thereof. In 1986, the court decided Bowers versus Hardwick, in which it held that a state could constitutionally criminalize consensual homosexual sex. And the majority opinion by Justice White and the concurrence by Justice Berger made it very clear by their explicit reference to historical practices and contemporary practices around the world that they regarded these historical and contemporary non-American practices as relevant. And they said this, to summarize, the world in our tradition has essentially set its face steadfastly against homosexual practices. Well, this case was decided in 1986, and they did not mention the embarrassing fact that 5 years earlier, in a case called Dudgeon versus United Kingdom, the European Court of Human Rights, maybe chasing the latest fad, the European Court of Human Rights had held that that was a human right not to have that criminalized. The court in Lawrence versus Texas in 2003 finally corrects the historical record and enters into a fairly extended discussion of what the state of the law is in the world. Now, I don't have any particular agenda with respect to those particular citations. I do, however, have a basic philosophy, and that is the more we know, the better. And if it is relevant to our thinking about legal problems that we have some comparative perspective, I think that's all to the good. I think it has a very limited role in our construction of our Constitution because our Constitution has its own frame of reference, has its own vocabulary, and so on. But the notion that we cannot even speak of foreign law, the law of which we dares not speak its name, is, I think, a dangerous and pernicious notion. The second one, in my previous remarks, I talked about the Constitution as containing a lot of negatives. The Supreme Court, because of its role in interpreting the Constitution, is, as it were, the head naysayer. There are two kinds of naysaying, and I think one it's pretty good at and one it's pretty bad at. The first one is protection of individual rights. That's been a historic role. The Supreme Court's pretty good at it. The justices and the lower court judges are protected politically so that we can do what we think the law requires us to do, free from the passions of the moment. I won't get into the litany of the particular lists of rights, some of which, of course, are somewhat controversial. I will just say in general that has been an historic role, and the court has been good at it. The second kind of naysaying, the court has been engaged in increasingly over the last several decades, and I think it is particularly bad at this. Jesse's written extensively, although without quite this vocabulary, on this same topic, and Jesse agrees with me, and that is the court speaking to the structure of government. On the structure of government, the justices of the Supreme Court are ignorant and distrustful. They do not understand the political process very well, and they deeply distrust it. Let me give you several examples of these sort of structural things as to which the Supreme Court has said no. For example, two recent cases, one of them, Morrison, the Violence Against Women's Act, the court struck down as beyond the reach of the federal government, a statute that under federal law forbade violence against women. In a case called Lopez, it struck down a federal law passed by Congress limiting the use or possession of guns near schools. Another one, separation of powers cases, Bauscher versus Sinar, struck down a statute designed by Congress in a kind of awkward way, I have to say, to get a limit, to get a handle on the budget deficit. A case called INS versus Chopra, something called a one-house veto, an arrangement by which Congress passed certain statutes to do various forms of reorganization, getting over various political difficulties by saying, well, Congress can step back and by one house forbid something that goes on under this statute. A very useful device. All you need to do is read Justice White's dissents about the number of statutes that were struck down when the court struck that down. Under both Bauscher versus Sinar and INS versus Chopra, both cases, the textual foundation for striking those down was slender as could be. I would say almost non-existent. But the court had ideas as to how the political process ought to work, and what Congress had thought was going to work quite well, and in fact by certain observations had already worked quite well, the court said, sorry, you can't do it. Free speech, in a case called Berkeley versus Vallejo, and this again picks up on a point Jesse made, in 1976, the court eviscerates a newly passed Campaign Finance Act based upon, again, slender constitutional text. Free speech says lots of, can be read to say many things. They eviscerated a once-in-a-generation campaign finance bill, and I think we're still recovering from that. I could give you more examples, but what I want to say is, as the justices have become increasingly ignorant of politics, they have increasingly intervened to prohibit constitutionally political solutions. If you compare the membership of the court, say, to pick a notable date, 1954, the date of Brown versus Board of Education, and you look at the justices, where did they come from? Well, the Chief Justice was, of course, Earl Warren, former governor of California. Two of the Associate Justices, black senator from Alabama, Minton senator from Indiana, and I won't go down the whole list, but they had enormous political experience. Beginning with the Eisenhower administration, a sort of hierarchical military generalist view of you promote colonels to general and so on, we became infatuated with the notion that the place you find Supreme Court justices is on the Court of Appeals. I'm here to tell you that's a lousy place to find Supreme Court justices. And we now have, with the retirement of Justice O'Connor, no one on that court who has ever been elected to any political office. Yet it is those people who are telling the Congress and the political branches what they cannot do based upon their reading of very ambiguous or almost non-existent clauses, which is one of the things I mean when I say getting in the way of solutions that might better our lives.
You know, there are really two different questions that we're talking about, very broad questions. One is, what ought the Constitution to look like? And the other is, what role ought the Supreme Court, vis-a-vis the other branches of our government or the people, what role who should interpret this Constitution? You know, it is adapted, no question, to deal with future problems. The question is how. And there is the notion that the court ought to interpret the Constitution to deal with all sorts of developing problems. Problems that probably weren't perceived, at least as debatable problems at the time. And on the other side is to say, well, we've got an article of the Constitution that talks about amending it. There are ways to amend it. And it was not contemplated at all that the Supreme Court is a continuing constitutional convention, changing things to keep up with the times. Well, I don't know the answer to that, but they are very separate questions. As to what there's been a lot of talk about the limits of the Constitution. It is very limited. It is very negative in the sense that it gives certain kinds of powers, but so far as to political institutions, but it gives virtually no powers to people. It gives people rights to not be regulated in particular ways. I think that's a good thing myself. I think one of the greatest problems in the country is inadequate medical care and inequality in medical care. But I don't, and I'm not as familiar with the European constitutions as other people. I didn't know that they provided for medical care. But that would be at the top of my list. More than employment and more than housing and more than welfare, which were and education even, which were the matters litigated to the Supreme Court. No one ever tried universal medical care or inequality, repairing inequalities in medical care. But the problems with making constitutional guarantees of a job, of a house, of an education, and of medical care is, these are the positive rights, as opposed to negative rights, saying, well, you can't do this to me. These are constitutionally instituted entitlements. And maybe it sounds crass, but it all comes down to money. And I think that's a bad idea. I think whether by statute or by constitution, the European countries, many of them, most of them, major European countries are in a lot of trouble economically. They can't make it work. And they're in a position, because I understand it mostly by statute, is to cut back on these things. And if we have it right here in California, in which we have entitlements under our Constitution, a certain percentage of all state expenditures have to go, or of all tax receipts, I guess, have to go toward education. A certain percentage has to go to state highways. We put these in, I think mistakenly, that we put them in. So what we do is we simply dishonor it. And we say, well, we're going to suspend it and it puts the court all sort of very difficult position. What's it supposed to do? Say, well, tax more. That's the obvious answer. Tax more. Raise taxes. How else are you supposed to get the money? I mean, either get it with a gun or through taxation. I don't think that's a good position to put courts in. The Constitution is not supposed to solve all of our major problems. It is supposed to put limits on governmental power and allocate certain responsibilities. Who is supposed to solve all our problems? Well, the political process. And at different times, different groups of us are very unhappy with the product of the political process. I've thought to myself, I'm the last one who ought to defend the political process. I have voted in 13 presidential elections in my life so far. 13, 14, who's counting? I have been successful in 2 of them. The last in 1964. is the last time that I voted for a winning presidential candidate.
I could have helped you out, Jesse.
But that has nothing. But that's the system that we have, and it seems to me, in terms of most public policy decisions, that's the system that has contributed. Who knows what has made this, the most powerful and successful country in the world? But the Constitution, I think, has been a major contribution, and I think we ought to be very hesitant to make major constitutional changes and tell the people that we must or we cannot do certain things. That's not to say it shouldn't be changed at all. I think it should. But I've given 3 matters that go to the very structure of our political process where I do think it has failed. It has failed, it seems to me, in reflecting the will of the people.
Aaron, go ahead.
So just briefly, I want to put the constitutional criminal procedural provisions back in the picture, because I do think that the 4th and the 5th and the 6th Amendment, the jurisprudence there kind of upsets a lot of the conventions of how we think of constitutional interpretation. You see some very strange bedfellows and some very strange arguments in this area. So you have the Kylo case where the court holds that it invokes the 4th Amendment for the police to use a thermal imager on your house, and the majority opinion staking out that terrain is written by Justice Scalia, and the dissent is written by Justice Stevens, urging the court to exercise judicial restraint and to leave things to the legislature and to not sort of go wading into these areas prematurely. And I think in general in constitutional criminal procedure, there is a different sort of mode that the court enters into, especially when you look at the past 40 or 50 years and see that in many respects the Supreme Court has become sort of the chief law enforcement officer of the country and has more or less occupied the field of what is good policing, what is a good interrogation or not, and not left really much room to legislatures to define their own processes or policing rules and regulations, or in some senses taken from them the responsibility to do that by setting out these very clear rules about how things should be done at a bare minimum. And so I do think that the picture is a little different. And I also think some of the ways in which we approach the Constitution have to be different. When you look at arguments on original intent, for instance, they don't work as well in the 4th, 5th, and 6th Amendment areas where the police force, as we know it, simply didn't exist back in 1791 or what have you. There simply weren't public police officers roaming around. That was a later invention. And so it's hard to look to understand exactly what the founders are getting at when there are simply not any references, or there's no concept of modern policing as we know it. So I do think also the degree to which the 4th and the 5th and really the 6th Amendment provide positive entitlements to defendants, right to counsel, right to juries, and so forth. And we see the Supreme Court dealing with that as a judicial branch, as a federal branch, essentially creating rules that turn into, in some ways, unfunded mandates to states to provide counsel, provide for juries, and so forth. We see in some senses the failure there of the institution's ability to really meaningfully implement those rights. So I think there are, in the criminal area, some lessons to be learned from the limitations of the role of the court, or ways in which we have to look to the Constitution for broader solutions than we've previously relied upon.
In the kind of issues that you're raising, in the digital age, the information age, in an age of increased surveillance technology, I recall a case in which the Supreme Court, I think it was Justice Breyer, was talking about whether there's a reasonable expectation of privacy in your bags that you put on a bus. As if any of the Supreme Court justices really ride buses. Right? I mean, they don't have the sort of work-a-day, everyday experience, and when you're trying to adjudicate something as to whether you have a reasonable expectation, what does a reasonable person think when they ride a bus, when they put a bag up on the top? Does that give you a little bit of pause about the confidence that we place in these 9 people to, as you say, be essentially the chief law enforcement? At least they write the rules. They write a substantial part of the rules of law enforcement in the country.
I think it does, although I actually, in this area, a lot of the things that I'm interested in talk about new technologies. So, for instance, radio frequency ID tags, the things you put on your cars to go through fast track, I think it's called out here, or get on the BART using just a scanning card. The privacy that you have in your computer when you send emails, your DNA, things like that. I actually think we're better off in some ways in this area than we might otherwise fear with technology for a couple reasons. One is that I think you're very right that I would be surprised to learn that any of the 9 Supreme Court justices had been on a bus anytime, or at least a Greyhound bus, anytime sort of proximate to when they wrote that opinion. But on the other hand, I imagine that many of them use email. They all have DNA. And, all of the things that perhaps really frighten us about invasions of our privacy are things that apply more or less indiscriminately. So that's part of the problem in Kylo, is that they're roaming around the neighborhood with the thermal imager. And I think a justice sitting at home, Justice Scalia in that opinion, worrying about the lady of his house taking her evening sauna and being perceived, has a better access point to understand the implications of the technology than kind of workaday, ordinary things like getting on the bus or so forth. I do think there's a real risk of the lack of an equality principle in constitutional criminal procedure, so that you could conceive of a world in which some of these technologies end up only landing on, as the burden, sort of on certain classes of people. So if you say that DNA can only be collected from arrestees, and we have a problem with fairness or equality in policing in terms of who gets arrested, then you're going to end up with a class of people kind of marked for further identification, and it extends out into the innocent world because, for instance, with DNA, your DNA not only reveals information about you and your health and your physiological characteristics, but it also tells a lot about your family and your relatives. And so you end up creating almost a criminal class. Or, there's a proposal from the governor to start essentially tagging sex offenders for the rest of their lives. And it really isn't such a stretch. Now they're talking about bracelets, but an RFID chip, there's actually some strange fellow who's implanted one in himself. I'm not sure why, but you can implant one in yourself, and frankly, it's less intrusive than wearing a bracelet. So it's really not hard to imagine we would implant chips in certain classes of offenders so that we could track them forever and so forth. So I think on the one hand, there might be an easier way for justices, even as sort of dissociated from ordinary life as those on the Supreme Court, to reference the fears and concerns of new technologies. And yet, if we create a class of people to whom they will apply that sort of eliminates an equality principle. Maybe you're just saying all BART passengers get indiscriminately searched, and you ignore the highway traveler in their limousine, or you ignore people who can kind of buy their way out of those kind of searches, then we're going to end up with some equality problems in terms of who those technologies affect.
John Yoo, what makes a good Supreme Court justice?
Well, I quite agree with Willie. I think that it would be much better for the court if they did not draw from the lower bench when they were populating, when the Senate and the President populate the Supreme Court. I think, though, the reason we care so much about the question is because the Supreme Court has become an extremely powerful institution in our society. If you want to set national policy on abortion or affirmative action, religion, death penalty, could go on, you have to now go to the Supreme Court rather than the political process to try to get your views known and to try to change national policy. And so, a different way of thinking this question is that actually healthy for our country to have the Supreme Court deciding all these questions? And if we limited the power of the Supreme Court, or asked, or the other branches were more assertive in their own rights to interpret the Constitution, whether we should care so much about who's on the Supreme Court. So, one way to think about it is, would it be, and this is sort of an interesting strand of constitutional law scholarship these days, is arguing against the existence of judicial review entirely, and judicial review being the power of the Supreme Court to strike down laws as being unconstitutional. Suppose we started afresh and had no judicial review at all. Would that actually make our country worse off or better off? We would have to fight through constitutional issues in the legislature. and perhaps that might be a good thing. That's the way we decided many constitutional questions until in the antebellum period. And it might have been better for our democracy that we do argue through constitutional issues and resolve them through the political process rather than relying on the Supreme Court to make all the decisions on these national policy issues. And just the last point is that it's all the Supreme Court's fault and all the time, but especially on this question, because I think it's because the Supreme Court has expanded its role in society that Supreme Court nomination hearings and the whole process has become such a zoo or a circus or political spectacle. So I don't really have any sympathy for the people who put themselves up for nomination or the fact that the political interest groups wage political combat through these nominations, because that's what the Supreme Court itself has done to the process of selecting its own members. If it was not so powerful and important, we wouldn't really care so much who was put on the court.